Disclaimer: the advice discussed isn't from qualified legal professionals. Consult a licensed attorney for legal guidance tailored to your situation. The creators are not lawyers and are not responsible for actions taken based on this information. This video is for entertainment only.
Is it illegal for my dad to put locks on the bathroom doors? I, 22M, live in Pennsylvania with my dad and younger siblings. For as long as I can remember, my dad has struggled with control issues and puts locks on just about everything in the house. The only areas of the house open to us are the upstairs bathroom and our rooms, even though we're not allowed to have doors either. Every other part of the kitchen is locked or blocked off. He puts padlocks and combination locks on the kitchen cabinets, the fridge, and keeps the downstairs bathroom locked with a key, which quickly became a problem with 5 to 6 people in the house. Now today, he made the decision to put a key lock on the upstairs bathroom too, so now we can't use the bathrooms at all. Is this legal? We can't shower, clean, or relieve ourselves now. NAL, but if your siblings are under 18, contact CPS. If you are being serious, I would report him immediately. In addition to the emotional abuse, it is also child endangerment. Where does he expect the children to use the bathroom? I watched a documentary on the Turpin family and how their children were treated, and this is chillingly similar. Please, if you and/or your siblings feel unsafe, are not provided enough nutrition or basic needs, seek help, especially if your siblings are not legally adults. Document everything. Take pics and video if you can of your living conditions. Call CPS as soon as you feel you safely can. This is abuse. I don't know about legality, but you're a grown adult being treated like a prisoner. I would start to seek out another living situation if possible. Annoying roommates would be a step up from not being able to have a door and being locked out of basic human necessities. Can I sue Jim for letting my daughter get mauled? My daughter was being watched at an on-site child watching facility while I worked out. She got open bite wounds all over from a child with special needs. They knew he had these needs and didn't have an aide or other person to help. I was not alerted that she was injured, and she was not given any first aid. I even witnessed and had to pull the other kid off her when I just happened to end my workout. I went to a supervisor and she also denied my toddler first aid. They have since contacted me and said not to worry about the situation and my daughter would be safe to be left there again because the woman was retrained. So I know for a fact she is still there after she let this happen. My daughter went to urgent care, a follow-up with her pediatrician was prescribed antibiotics, and she may potentially need hepatitis testing. Is this grounds to sue? The medical expenses weren't that expensive after insurance, but the traumatic effect on her and I, as well, has been huge. You can probably go to small claims court to recover the money spent on treatment for your daughter, but you should probably speak to the gym and ask them to cover the costs. Either way, all communication regarding this incident should be via email. I hope your daughter wasn't too traumatized by the incident. Yeah, I would say so. You can claim for your daughter's injuries, and the money can be held in a trust until she's 18. If the staff has been retrained, it shows a mistake was made. I'm a lawyer. Find a good personal injury lawyer and meet with them. That was a very serious assault, so I do hope you reported it to the police. I would suggest contacting your state's abuse hotline or whatever other entity is supposed to monitor childcare in your state and report this facility for neglect. I have contacted local and state police, and it is being investigated. In the US, anyone can sue for just about anything. The question is always, how much will filing a lawsuit cost, and will these costs be more or less than any expected damages received? I strongly suggest that you consult a local attorney. In most states with which I'm familiar, childcare facilities have to be licensed, even those in gyms, so you might report this incident to whatever entity in your jurisdiction provides that licensing. It's not clear when this incident happened, but did the gym provide an incident report and its insurance information to you when it happened? They don't have to fire the supervisor who was not helpful to you when it did. I asked the head nurse to keep my call anonymous, and she didn't. I knew a nurse was stealing and using fentanyl, so I called and reported it to the head nurse. Nothing happened to the nurse I reported, so I called again 2 months later to report her again. I told her I would like to remain anonymous and did not leave her my name or contact info. She told the nurse I reported that the first time I called, they swept it under the rug, but since I called the second time, they'll need to test her. They also ran my number from caller ID. I did *67, so not sure how they got it, and told the nurse who I was, which is an issue because she is an unhinged person that I fear for my safety from. She is a former friend and knows who I am. The nurse has since been tested and failed, and I think she has to go to counseling. I didn't really hear an update. Am I being dramatic, or should I let it go? This should have been reported to the Board of Nursing for your state. As a nurse, you have an ethical, moral, and legal obligation to report per the Nursing Code of Ethics. Many times, places of employment will simply terminate or gloss it over. Please report to your state's board. Unfortunately, you didn't report to the proper people. Head nurse is not a role. Charge nurse is more like a coworker than a manager. I work as a nurse, and I've had all kinds of people calling up accusing the hospital staff of stealing drugs, being part of the Illuminati, harvesting organs for human sacrifice. Just calling and telling the nurse's coworkers your suspicions wouldn't automatically trigger an investigation. More likely, the nurse did something to trigger an internal investigation, acted intoxicated at work, messed up narcotics count, yada yada. And it's just a coincidence your reporting also happened. Just calling a hospital and reporting your suspicions to a random head nurse does not offer you any privacy protection. Please report to your local or state health department. I'm a state health department employee. We investigate these instances to make sure any patients whose medications were tampered with did not become infected with bloodborne pathogens, and if they were, we coordinated treatment. Also, as other Redditors have commented, your compliance officer should be 100% notified and the DEA tip line is great. Drug diversion is a serious crime with criminal consequences. If the reason you know your identity was revealed is because the nurse you told on told you, you should consider the possibility that they simply suspected it was you and bluffed you into confessing. Heck, they may have suspected several people and tried accusing everyone to see who would fold. Just fell through the floor of a closet with my infant. It turns out that the part of the floor was just the drywall ceiling of the garage. Thankfully, things went almost unbelievably well for the baby and me. I landed on my feet on top of some mattresses I had improbably placed in that very location on our move-in day, and came away with a scraped up arm and a very startled infant. Thank you, Lord. I'd be interested in what to expect as I consider taking legal steps against our landlord. We moved into this house in Georgia just a few days ago. Even though this closet in our 20-year-old rental is unfinished, it's listed on the building plans as a closet and even has a window. I had been in there a few times and nothing had indicated to me that this section of the floor was unsafe. Relatives have told me that this is likely a building code violation, and the fall was far enough that serious injuries or worse wouldn't have been unlikely, especially since I was holding a baby. Get an inspection because there may be other areas where the floor is not properly supported. You got very lucky. You might want to get a checkup on the baby because that's a pretty significant amount of shaking. Also, keep an eye on your own joints. To the extent you do need to get medical care, that would need to be covered by your landlord. You could potentially also get out of the lease on the basis of safety. Also, in addition to what others have posted, take pictures of the hole in the floor and any injuries you and your child have. This will help protect you if there are allegations against you harming your child due to the fall and if the landlord tries to charge you for the cost of the repair. I would be worried about the stability of the rest of the floor above the garage, to be honest. Tell the landlord immediately. You and the baby go get checked out ASAP. Insist that the rest of the floors above the garage be checked out. So it finally happened. I now have a housemate without my permission. My uncle, the landlord, just moved a stranger into my apartment without my permission. It's literally my and my mother's apartment, but he just did this without asking us. Even though we said we didn't want to, he's collecting money from his new tenant, and we didn't agree to having him. And now we have to live with him. I'm in a state of disbelief. The house is a wreck because of him. He's completely destroyed this place and refused to fix anything. There's no roof on the building, and there's mold problems that smell really bad. The upstairs bathroom sink doesn't work, the kitchen sink's messed up, the stove is destroyed, and there's a literal hole in the floor of the front bedroom that's over the dining room. And somehow he thinks that moving in a tenant into an apartment that we own is a good idea. What can I even do? It's hard enough just living in this horrible place. He knows that we don't have the means to move yet, and he thinks he can do whatever he wants. He even just opens the front door and walks in whenever he feels like it. He put a lock on our room, but insisted on having the other key. This is unsettling, considering that he doesn't respect anyone's privacy. I think this post is characterized misleadingly, since it states that this is a landlord-tenant issue, and you refer to your uncle as the landlord. But from your response to the other comments, it sounds like both your family and uncle own the property. So it sounds like this is more of an issue of right to possession of the property and whether the uncle has the right to lease out his interest without your approval. It's not clear whether this is joint tenancy or a tenancy in common from your description. Therefore, it is my advice that you see a property attorney who can help you understand what type of ownership you have to the property and how best to remedy your situation based on what tools are available to you under the state of locality where you live. There's a lot wrong with this post. You need to have more information other than just a rant about how you don't like the guy being there. You call your uncle the landlord, but then say you own it, and in the comments you claim it's jointly owned. It seems like what you need is what's called a partition action. It's a legal proceeding that will compel your uncles to place the property for sale. The somewhat good news here is that these can often be done on a contingency basis. At least they are where I am. And that means an attorney with no upfront expenses. How can he insist on having a key to your room? What's he going to do if you change the lock and don't give him the key? If your mom co-owns the building, she has rights. This is a mess, hahaha. But yeah, if you own part of the property, the best you can probably do is demand a portion of the rent, and demand he pay a portion of upkeep on the property for non-aesthetic repairs. Can police search my house based without a warrant based on someone's Find My Phone? I got woken up really early in the morning, 2 a.m., by two ladies asking if I'd been to a local bar. One of them claimed to have lost their phone and that they see it on their Find My Phone pinging in my house. I definitely didn't go out to the bar last night. I went to bed at like 10 o'clock, so there's no way I have this lady's phone. Nor do I have any phones other than my own work and personal phones in the house. However, I caught one of them saying, we'll just have the police search for it. Can police search my house because someone claims to have found my phone data showing it's here? Or would they still need to present that evidence to get a warrant? Mainly just want to know whether that would be probable cause. If they have the right to search based on that, I don't want to catch an obstruction charge. But, like most people, I also have no desire for a bunch of cops to rifle through my stuff on a wild goose chase. Washington State, if that's relevant, Hoping this is just some kind of B&E scam that I didn't fall for. Update. Sheriff deputy did come by this morning asking about it, so I don't think they were actual scammers unless someone is also impersonating an officer. Stuck to the plan. Didn't know anything about this and didn't leave my house. No further discussion without an attorney. No. Find My isn't accurate enough to get a warrant. According to Find My Phone, I am currently sprinting between my neighbor's living room and my backyard. This is a common scam. I'm not sure if the ultimate goal is to case a house to rob later or what, but this exact thing happened to me. They never called the police and ended up leaving after they saw my giant dog. Tell them to dial. Set off the lost phone alert tones, etc. Don't hear a thing? Bye. It's possible for them to get a warrant, but most of the time they won't bother. I've dealt with this before when people break into work van and take laptop and phone, and I can track it literally to the dude's house. But cops didn't want to fingerprint nor deal with it. Just said that this serious crime was a personal, civil matter. They just gave me a business card with a case number for insurance purposes. Remember, cops aren't there for serious crimes. They're there to extort you for money and shoot innocent people. That's true. That's very true. That being said, since you didn't commit this crime, it's likely a scam as others are saying. Don't worry, even if you committed the crime, you're unlikely to face repercussions. Casino says I owe them several $100s. Casino told me that I took a certain amount of money in chips to the cashier's cage and that the cashier gave me several $100s too much money. They say they have footage from a few days ago of me bringing the chips and the incorrect amount of money being given to me. They said next time I come in, they are going to want the money back. If I don't come in again, will they pursue me over several $100s? They said they can't provide photos or videos to prove that they are saying because of gambling regulations. They have my name, address, SSN, and footage of me playing there. Why does your casino have your social security number? I used to work in the surveillance for a large casino, and I reviewed similar matters all the time. This is common for casinos not to provide any extra details to you. Overpaying and even underpaying happens a lot, and we handle the repayment the same way you listed. What you can do is go to the Gambling Control Board for your state. I do not know your location, but I would imagine most states have it mandated for a representative to be located on the casino premises. The control board will have all the details and they can view the surveillance footage. Apart from getting a lawyer and going to court, this is most likely your best course of action. Edit just to add some other details. We typically would not call someone to tell them they owe money. Usually it is listed as a remark on their player account and it gets flagged next time they come in. However, if a member of the staff has a really good relationship with the player, then it would not be uncommon for them to call and notify them of the error. You typically only see this with poker players and VIPs. Ex-casino cashier here. If you know you were overpaid, you should return the money if only to save the cashier's job. Depending on how much money they overpaid you, they could be losing their job. If this casino is owned by Caesars, MGM, etc., then you can't go to any of their properties until you pay the variance back. If it's under $500, it's likely that they won't come after you legally, but if it's more than that, then you can expect some letters from the casino's legal team. They will have proof internally that they overpaid you. The way they are taught to stack chips and count you out money is exclusively for surveillance to watch and be able to verify amounts. It probably makes a difference if they gave you $500 for $5 worth of chips, or if they gave you an extra couple hundred on $2,000 worth. The latter, you could have innocently relied that they settled your account accurately. Not so in the first case. Judging by your question dodging, you were overpaid and you know it. Just pay it back. I worked at a large casino for 4 years in a few different departments, and usually overpayment would be something the cashier would be reprimanded for, not the gambler. Maybe tribal-owned casinos operate differently. OP didn't specify who owned the casino. NAL. They will trespass you at all of their properties, and you would technically be breaking the law by going again. Source. I was paid $100 on a losing hand of blackjack. Security came back and said give it back or to leave. I left, but I had a nice surprise when I went back. If you were overpaid, just give it back. Friend had a $33,000 instrument stolen and the police will not help. My friend had an instrument worth $33,000 stolen out of her apartment in New York. It was the only thing that was stolen, meaning whoever stole it knew what it was worth and had to follow her and watch her to know when she left without it. She's a music student, so it goes with her pretty much everywhere. She immediately reported it missing to the police and posted on Facebook in the hopes of getting leads on who took it. She also called pawn shops and reached out to more specialized communities to make them aware. Someone reached out to her and let her know that they witnessed and even spoke to a man, likely homeless, walking down the street carrying a case matching the description of her instrument not far from her apartment. Using this lead, she was able to go around to local businesses in that area and ask if they had footage of this man with the case. One business had footage of the man and she was able to confirm that it was her instrument he had. She went to the police station with this information and she was told to go back to the location and call 911. When she informed them she'd done so twice, they told her she should have asked to speak to a supervisor. They simply added new information to the file. Since then, she's been walking around town in all of her free time in hopes of finding either her instrument or the man who took it. A different person reached out to her without giving their name and informed her that he thinks he bought her instrument. He wants her to meet up and pay $1,500 to get it back. Of course, she immediately told the police about this update, and they told her it's her job to get this person's address. She asked if someone would escort her to meet up with this person and help get her instrument back, and she was denied. She tried setting up a meeting in front of the police station with the person to get her instrument back. The person refused and said he wasn't out to get her, but he doesn't want the police involved and he doesn't want to lose out on his money. In the past hour or so, another friend was able to look up the phone number being used and found the name and possible address. We are waiting to see what happens next. Can she press charges against the man who currently has her instrument for extortion or other similar crime? Can she pursue legal action against the police for being worse than useless? I'd consider the $1,500 the excess on the insurance they don't have. The police won't want to follow it up, especially if the perpetrator is homeless. They'd have no money for the state to go after, so it's worthless to them, bad as it sounds. Operates the same in a lot of countries. The state press charges, not your friend. Your friend can notify the police about the man. No, your friend can't force the police to do anything. The police have no obligation to investigate every single report that's made to them, as doing so would cause operating costs to skyrocket and reduce manpower. It's doubtful that this person has your friend's property. Unless your friend has some way of verifying it's her instrument, she should take it with a grain of salt. I would just pay the dude $1,500. It's better than losing the instrument completely. The police aren't going to do anything, and I bet the guy will take $1,000. He probably bought it off the homeless dude and doesn't want to lose the money he bought it for. Even if they find that dude, most likely they will not recover the property. Cut your losses while you still can. Neighbor's landlord gave someone permission to cut down my trees. Hey everyone, I'm very upset over what went down today on my property without my consent. I own my property in upstate New York in a city, and the lot next to me has 2 duplexes on it. The duplex in the back of the lot is built right up along our property line border, which is pretty normal. There have been multiple tenants over there the past few years that have thrown their trash out their window into my backyard, but that's beside the point. This afternoon, I looked out my back window and saw a ladder set up in my yard to get to their roof, and a decent chunk of the trees gone from my yard. I immediately went outside to take pictures of everything and call my partner. My yard is now also covered in nails and old shingles. A couple of my trees were trimmed where they crossed the property line, which I know is legal and fine, and I don't care about those, but 3 of my trees were completely cut down to the stump and discarded also in my backyard. One of the roofers saw me take the pictures and came down to tell me that the owner of the property they were working on said to just cut away anything in their way. Pointed out that the trees were only 3 to 4 inches in diameter each, so not a big deal, and said if I wanted, he would go to the Home Depot and buy me new trees on the spot if I wanted. I never met the neighboring landlord and in no way gave him permission to come onto my property, let alone other people onto my property, or cut down my trees. I got his contact information and spoke to him over the phone. He claimed he had tried to talk to me but couldn't because I was never home. I have a full-time job. And when I pointed out that he had no permission to cut down my trees, he threatened to sue me because another tree that they trimmed had allegedly caused damage to said roof. I was never notified or approached about that in the past. My backyard is very small, but part of the appeal for my partner and I is that it's very green and has a lot of trees and vines that keep it shaded. Somewhat private and naturally beautiful in an otherwise overcrowded and gray area of the city, and now a chunk of that has been stripped away. I am meeting tomorrow with a family friend that works in a local code enforcement tomorrow, but my parents think I should just let it go. Meanwhile, I'm so upset, stressed, anxious about this, and I know tree law is kind of a big deal, so I was hoping someone here could let me know if this is something I can pursue and if I should be worried about him countersuing for those supposed roof damages. Roofer offered to buy you new trees because he knows he is big time screwed. New York tree laws are nothing to laugh at. New York law allows for a penalty of 3 times the timber value or $250 or both for each tree removed without owner permission. Plus whatever city laws are broken, consult a property attorney ASAP. Whatever you do, don't let it go. He had no right to cut those trees, and even worse for him, he has every obligation to replace them plus compensation. Speak to a property attorney and gather as many photos of the trees that you have as possible. They are to replace them with trees of the same size and species, and depending on age, that can get very, very, very expensive for your neighbor. Don't let this go. You're about to get paid. Call an arborist to come out and give you an estimate of the cost of tree replacement and then take them to court. This is nonsense. They could have contacted you first about this. I had an arborist come by and do some minor trimming and tied them back after. I had 4 mature cedars up against the house. They untied them after. No need to cut them down. Usually if they are hanging over the property line, neighbors can cut them back, but not the entire tree. My new landlord is a cop, and I believe I'm being harassed. My apartment was bought out by a cop. They, the landlord, brought another person, show up with absolutely 0 prior notice, and knocked on my door and tried to walk in without me even opening the door. I meet them outside, and I'm given a foul attitude right off the bat. I'm pointing out the issues I have with the place and all the other, and I'm told none of it will be fixed unless I give them money first. I still have a security deposit from the previous landlord, so that should have been transferred. I should mention right now that I'm a DA survivor, and it's well known in my area that I am. Both of them walked closer to me, basically pinning me against my door, asking me things that they shouldn't be asking about my personal life, where I'm from, etc. I was trembling super bad, my voice shaking, the whole 9 yards. They both stooped down and go, "Aw, are we making you nervous?" and walked away from me laughing. After they left, things have been going wrong in the apartment. My hot water has stopped working along with my heat. Both the hot water tank and the furnace are in the basement. The basement can only be accessed from outside. Me and the neighbor are connected and we share a basement. And the door to the basement has been screwed shut with screws my neighbor nor I have. I also have a child and they're aware. I'm already in the process of looking at other places and have been the whole time I've been here, but it's so difficult. NAL. But it sounds like you need to carry a recording device for these interactions. Research if you live in a single party state, so you won't get in trouble for it. Also, call your local councilman's office and ask for what resources are available. But do not tell them the whole story. They might know the cop, and that could come back to you. You need to consult a lawyer. What does your lease say on heat and hot water being provided? Do you pay for your utilities? How long has it been without heat or hot water? Also, where are you located? Certain towns and states have different laws. You could withhold the rent until these items are repaired. These people saying you need to pay them before everything is fixed is BS. They got your security deposit transferred from the owner. If not, then the cop has to speak with him, not you. It's not your problem. Cop needs to better himself on landlord/tenant's rights. This is a very dangerous situation. You should not be attempting to live here longer. I know this is a legal advice sub, but you need to get out of there. Absolutely no tenant's rights will protect you if a police officer claims he heard a scream inside. NAL. Saw this was NY, looked up NYS legal aid. It will help get you a lawyer to help you deal with your landlord and can be free depending on your budget. A decade ago, we had a landlord who refused to fix anything, so we left the house trash when we moved. He took us to court, legal aid got his petition thrown out. Boss sent lingerie to friend BF and friend was terminated. Hi there, posting for my friend in Washington. She is shook. She works at a leasing office for an apartment complex. One day at work, she got a package delivered to the leasing office. It said her boyfriend's name and their address with unit number by Amazon. She lives on property. She called her boyfriend who told her to open it as he didn't order anything from Amazon. She opens it again and it's a lingerie set that said, "See you again, AJ." She calls Amazon and figured out who sent the package. Amazon says if she can guess the name of the person, he can confirm it. She guessed her female manager. Amazon confirmed it. The initials are not the manager's name, by the way. We still don't know who these initials are. Boyfriend, tenant, files a complaint against this manager for sending inappropriate package. My friend goes on her manager's computer and sees the Amazon account was still logged in and checked the orders. Confirmed placed by the manager. There is a note stating for Amazon to deliver to front desk. He sent info to HR. HR terminated her for unauthorized access to manager's computer, no warnings. Washington State. Does she have a case to fight back on his termination? No. Having unauthorized access to a manager's computer is a legal reason to be fired. Would she be able to collect unemployment? She can apply, but would almost certainly get denied because she was fired for violating company policy. Legally, not much you can do, as the other response clarified you did break company policy. Your best recourse is for your friend to reach out to the corporate office, although they won't take kindly to either of your actions. There is a non-zero chance for them to take action against the manager. Harassment of tenants does not look favorably on a landlord. Yeah, she did mess up. Accessing her manager's computer secretly was a huge mistake and very clearly a termination event. Accessing somebody's computer without their permission is technically a felony, so no, she has absolutely no leg to stand on. She should talk to an employee attorney in Washington. There may be an argument that the firing was pretextual and retaliatory. At least there might be enough of an argument for her to get the firing changed to a layoff and maybe get some severance. Neighbor knocked and then entered my apartment. So my neighbor knocked and rang my doorbell looking for me. I was asleep and woke up to him shaking me awake. I woke up and asked why he's in my apartment. And he said I knocked and rang the bell multiple times and you didn't answer, so I came in. I got angry and asked why he would enter my house when I didn't answer the door. It was left unlocked, by the way. And he got mad and ran his mouth bad for being upset at him being in my apartment. Is it a crime what he did? I live in upstate New York. What he did was wrong, but lock your door. I mean, it's trespassing, but I would imagine nobody would prosecute this. Use your lock. That's what I thought also. Thanks. You can file a trespass warning with the police, so it will be on permanent record. Anyone that has exclusive use of a property can trespass someone for their property, barring contract such as residential lease. Did he say why he was doing this? Is he a bit off socially? Seems odd, and a quick way to get shot if he does that in the wrong place. At least he wasn't robbing you for anything. For some reason, this was normal in his mind. My employer just denied my request to have my service dog. I work for a pretty large trucking company, and they just denied my request to bring my service dog with me. I've been working for them since January, but only asked now because my dog had to have surgery, which unrelated, but the only reason I got CDL in the first place was to be able to take her to the vet. I asked what the process was to bring her with me, and I needed a note from a doctor, and they told me that they don't allow pets of any kind. I explained to her that she wasn't a pet, she's a service animal, but she kept repeating that they don't allow pets. I'd also like to point out the fact that it isn't even true because they allow team drivers to have pets. She told me she'd ask someone higher up, And just a minute or two after our phone call, she sent me a message saying service dogs aren't allowed even with paperwork. Isn't this illegal? I'm not sure if the same rules apply to trucking companies or if they somehow are exempt from the reasonable accommodation laws. Edit. Yes, I am disabled, and yes, my dog is trained. I'm less concerned about my ability to take her with me and more concerned about other people who may need service dogs. I can survive without mine, although she does make my life easier. Some people may need a service dog for allergies, celiac disease, etc. Those things can be life or death, but don't affect your ability to drive a truck. I was told they don't allow dogs, service dogs are not, and she shut down the conversation and wouldn't discuss it with me. NAL, but as an employer, I've had to deny a service dog accommodation and go through the process of the employee appealing, etc. I also have some knowledge of the trucking industry. My concern for you, with not being upfront about it during your hiring and onboarding, is that most medical conditions that service dogs are commonly used for will disqualify you from having a CDL altogether, and you may end up unemployed again. Was the disability your dog is providing services for reporting during your DOT physical? There is a list of disqualifying conditions on the DOT website. It sounds as though you want to bring your service dog to work because it has recently had surgery and the dog needs more frequent care from you rather than you requiring the dog to perform any particular task or support while you're at work. Maybe I'm misunderstanding, but if this is correct, perhaps your job is coming to the same conclusion that you don't actually need the dog at work, and thus the accommodation you are asking for is not reasonable. My bank deposited a legitimate check that they think is fraudulent and have frozen my account. I deposited a check last week for $2,000 from my old landlord. The funds are in my account and have been taken out of my landlord's account. My landlord proved this by sending me a statement along with a picture from his bank with the check and my signature from the electronic deposit. Chase froze my account and are closing it in 10 days and withholding the money from that check. They are saying it will be in limbo for 2 years, basically until a resolution is found, and says there are a few options. 1. Provide them a phone number to call that is associated with the business. We did that, but since the phone number isn't under his name, though his phone company, determined by a third-party security system, they cannot call that number. Talk with our landlord, and he basically is telling us he can't give them any other phone numbers, and that's not his problem. Dead end. 2. They have tried to call his bank, US Bank, but they can't give them the info needed for security reasons. Dead end. 3. Our landlord would have to ask his bank to cancel the check, but he is hesitant since the funds are out of his account, and even Chase says that doesn't always work. Not sure what that means. Ultimately, Chase has taken our money and plan to hold on to it for reasons that we cannot control. Are there any low-cost/no-cost legal steps we can take? File a complaint with your state's bank regulatory office. It might be called Comptroller, Division of Banking, etc. Google your state bank regulator. Mail a complaint with the CFPB. That usually gets the ball rolling. As said, start with CFPB and also state agencies, Attorney General, etc. I would also open an account with a credit union. Do that ASAP so you have a place to deposit your pay and also cover bills while this is ongoing. Read the contract to see if it provides for arbitration. If it does, then file a claim under arbitration. If there is no arbitration clause, then you can sue them in small claims court. If you are not able to resolve with the bank, contact the regulator. Odds are good this is driven by some sort of compliance thing. If the bank makes an exception to their compliance rules, it can get them in big trouble. If a regulator suggests they can make an exception, the bank is in the clear, because it's not their fault if you are secretly evil or something. Can a customer sue us for refund of merchandise they willingly purchased and was not misrepresented? We have a customer who purchased an expensive necklace. In fact, it is the most expensive piece in our store. We disclosed the price, metal, solid 14-karat gold, and gemstones. The piece was over $1,000 and had 2 times markup for us, which is pretty low markup compared to most of our pieces. When she purchased it, she told us that she wanted to splurge on herself for something nice. She purchased the piece with her credit card, signed the receipt, and left happy. 3 weeks later, she calls the store and tells us our employee that she thought the item was only $20 and wants a refund. Our employee has my husband call her. She professes to my husband that she did in fact know the cost, but she realized she can't afford the piece and wants to return it. Our register has a giant sticker that says no refunds, and in our state, we are not obligated to refund unless the merchandise is defective or misrepresented. The customer told my husband that she needs her money back because she has bills to pay. He told her the same. She's now had a lawyer send us several letters telling us that she was told the piece was $20 and we need to refund her since no contract was formed. We've ignored the letters and have no intent to refund her. As a very small business with less than a year in business, it will hurt us quite a bit to pay that back. Also, since it took her a few weeks to even contact us, we have no idea what has happened to the piece since then. We can't sell it as a new piece if we take it back, and we'll likely lose money if we do. But does she have a case against us? I haven't lost any sleep over this, but just curious what people think. They're probably going to dispute with their credit card company next. Just be prepared with their signed receipt and whatever else your financial institution asks for you. You will win this dispute. You have a contract. You have an offer, acceptance, and consideration. They are arguing that there wasn't a meeting of the minds on price. If you have the signed receipt, then it would be hard to argue that she was not aware of the sale price. Along with checking with the firm, I'd also check this person's social media accounts. I have a suspicion they bought it for an event with the intent of returning it after the event was over. No lawyer would accept this without upfront payment of fees, and they definitely would never try to take it to trial. No, you don't owe her anything. I deal with chargebacks on an irregular basis, but I've almost never had one go through since I keep every signed receipt. Thank you everybody for watching. Make sure to leave a like, comment below, subscribe, turn on post notifications to get notified every time this channel uploads. Again, thank you for watching. Have a wonderful day.